turn this here slightly. Scott and I are going to split up this presentation. I'm going to give you a little bit of background on the Republican River Compact. Justice Hobbs is always a hard act to follow, but he did a great job kind of describing the framework in which we work in Colorado and this uniqueness that we have in our tributary system, and he talked about the designated groundwater. In one of these unique roles that we do as a state engineer's office as being the administrative agent, I'm appointed by the governor. I work in the executive branch, and so we have those roles and responsibilities as it relates to the administration of water, both surface and groundwater. One of the unique things in Colorado, we also have the judiciary, the water courts, where we adjudicate these water rights. And particularly when we're working in the Republican River Basin too, when we're talking about the complexities out here, we've got the designated groundwater basins, which came about after the creation of the 1965 Groundwater Act, and they created a designated groundwater basin out here shortly after that. And also the surface water in the streams themselves are administered under this doctrine of prior appropriation that Justice Hobbs talked about. So when there's matters dealing with those adjudications, those are all done through the water court, through Greeley. So we've got this overlay of administrative systems that we have to deal with out here in the surface water context, the designated groundwater context, and to any limited degree, there's any kind of non-tributary water that may be determined out here also may come into play there. So just keep that in mind as we go forward through this and talk about how this has evolved and the complexities that come about because of this, these systems that we operate under. Okay. See if we can get this to work here.
You might have to reach over the podium there.
Oh, there we go. Justice Hobbs talked about the 9 interstate compacts we had. I want to just highlight a little bit about the Republican River Compact and how some of its salient provisions in here. But as you heard Justice Hobbs talked about the history in Colorado and when there's disputes between the states, early on in the late 1800s, early 1900s, how they resolved those matters was by filing this complaint with the U.S. Supreme Court. It's a very long, litigious method. We went through it on a couple of our streams in Colorado, in the Laramie River and the North Platte, that ended up in a U.S. Supreme Court case decree that was entered that we administered like a compact. But they learned early on that this litigation method was not the preferred method that they wanted to go through. Because it was, you spent a lot of time with attorneys and litigating this, and you then had a judge or justices in this case decide your fate. So the early conveners in Colorado, we talked about the people that started the framework of the compacts and relied on this, Delph Carpenter. They recognized that the compact method was a preferred alternative to the litigation method. And our earliest compact started in the 1920s in the Colorado River Compact, South Platte, and as we moved along up into the 40s, 50s, and 60s, we entered into this compact on the Republican River as well in 1942. And as Justice Hobbs pointed out, these are ratified in state statute in each of the states, as well as approved by the U.S. Congress and approved by the President of the United States. There's a lot of major provisions that are in each of our compacts, and particularly as it relates to the Republican River Compact. If you remember, came after a significant flood here in the basin in 1935, and there was a strong interest in addressing flooding issues out here and working with the other states and the U.S. government. So there was efforts underway to try to determine how we're going to allocate the waters, surface waters that they knew existed at the time in these streams. So this compact method allows each of the states to sit down and really look at this in a holistic way and look at it more kind of in a scientific way and gather data to try to understand how the system operates and try to work out an allocation system based on that knowledge. And so it was in an effort to equally divide the waters amongst the 3 states. And keep in mind, back in the 1940s was being developed, there really was no groundwater development at the time. And so when you look at these provisions in these compacts, starting in the 1920s all the way up into the 40s and 50s, and even into the 60s, you'll look through this. It's very poignant when you stand and look today back. They didn't deal with things like groundwater development. They didn't deal with things like the Endangered Species Act. They didn't deal with things like climate change. we're now faced with these things, and these are some of the reasons it's created the conflicts. And Scott's going to talk about some of those conflicts that we're embroiled in today and how we're trying to resolve those. But one of the other provisions of the compacts is to create this interstate comity so that, we can, if we do have a conflict, we can work through these administrative bodies that are created out of these compacts to work amongst the states and work with the facts that are there and try to resolve these outside the context of filing another suit before the U.S. Supreme Court. These compacts recognize it's an efficient way to utilize the waters. Justice Hobb talked about this, and beneficial use is very number one, paramount in any allocations of waters under these compacts. You got to put them to a beneficial consumptive use, and we recognize that certainly as well in the Republican River Basin. I have to make sure I point this. There we go. Like many of the compacts, they all have different provisions in them, but specific to the Republican River Compact, it allocated the surface waters in the basin amongst the three states, and Colorado, just like the other two states, had specific allocations to them. And you'll see a listing here of what those allocations there are principal allocations and that we deal with on the North Fork, the Rickery, and the South Fork. And so we'll focus a lot about that as well as we talk about some of our efforts to come into compact compliance really revolves around the North Fork and the South Fork. But these other basins are important too in terms of our accounting procedures with the other two states. As we mentioned, that the compact sets up a governing body. This one that's in the Republican River Basin is referred to as the Republican River Compact Administration. Each of the states have a representative to that commission. I'm the representative for Colorado. David Barfield, the chief engineer from Kansas, is the representative for Kansas, and also Brian Dunnigan, who's the director of the Nebraska Department of Natural Resources, represents on behalf of the state of Nebraska. This body meets at least once a year, can hold special meetings. We usually meet in the summertime to decide on matters that are important to the commission, deal with all of our accounting for the prior year and any other years that have been undecided, and any disputes that may come up. We work through this body as well as an engineering advisory committee that's got representatives from each of the states as well. It's been integral to our efforts in working out, particularly as we talk about some of our compliance effort. This body and that engineering advisors really assisted the three representatives to the commission as we work on those difficult issues. So Justice Hobbs talked about this, statewide we dealt with this evolution of use of surface and groundwater under the prior appropriation system as a good method to develop our water in the state as we grew as a state. But as we recognized, as we kept continuing to grow and we kept utilizing more of this scarce resource, we talked about the drought of the 1950s. The technology came about to have turbine pumps. Rural electrification came about. And so you saw this rapid development of wells in eastern Colorado, not only in the South Platte and the Arkansas, but in the Republican River Basin in the 50s, 60s, and 70s. Colorado recognized after we created designated groundwater basin in the mid-60s and into about the mid-70s, we recognized we really were at a point that we've overallocated the available resources in the basin. We put a moratorium essentially on well development in the 70s, as well as Kansas, and Nebraska continued in its well development into the 70s and 80s and 90s. And this raised concern by Kansas, and they raised this numerous times with Nebraska about this concern of this rapid and ongoing well development in the 80s and 90s. And those discussions weren't fruitful and resulted in a case that Kansas filed in 1998 against Nebraska, and it claimed that the groundwater wells were connected to the Republican River and its tributaries. They had an understanding of this connection between surface and groundwater, and that Nebraska was overusing its allocation. Well, in 1999, the U.S. Supreme Court accepted this case, case number 126, in original jurisdiction And they appointed a special master, McCusick, to this case. And every time an original jurisdiction is brought, at least in our water matters, before the U.S. Supreme Court, they'll assign a special master to that'll hear this case and provide findings to the U.S. Supreme Court ultimately. And Scott will talk more about that. Because Colorado is a signatory to this compact, Colorado was brought into this suit as well in 1999. And as I indicated, this is 126 original. And I think there's only, about just a little over 140 original jurisdictions that have been brought before the U.S. Supreme Court on these water matters. We can get this together. There we go. What's it? Did I go backwards? Oh, I did. Thank you.
Push down.
I'll get this figured out, folks. What's crazy is, you got one control we use that the top button makes it go one way. This one goes the opposite way. Okay. That's why I got him here to help me out. Special Master McCusick, who was involved in this case, think about this time frame when this case was filed in 1998. Colorado came in 1999, was on a very rapid track. Justice Hobb talked about this case we had on the Kansas v. Colorado on the Arkansas, started in 1985, went for 24 years until 2009 before that case was resolved. The courts recognize these cases can't take that long anymore. We've got to move through these quickly. Special Master McCusick worked on a very fast track through this case, and you'll see through these timelines. But they recognized in his original ruling that he found that this groundwater included within the allocation of our consumptive use allocations under this compact. And this is the consumptive use associated with the stream depletions from groundwater pumping. So keep in mind, as we pump these wells out here, a large portion of this comes from the groundwater resource itself. There's a portion of that then also that has an impact on the stream system and affects stream flow or base flow in those stream systems. And so they recognized that this was important and needed to be considered. And so the special master encouraged states to work together to try to resolve these issues. They worked on a settlement that became known as the Final Settlement Stipulation, or the FSS. You'll hear us refer to that throughout this presentation. And that was approved by the states in 2002, and the U.S. Supreme Court then approved that in October of 2003. Let's point out a couple of provisions underneath that. One of the key things, the provision of that final settlement stipulation is you can imagine as we institute this new settlement, how it would apply retroactively to prior years. Well, they recognize that this could be very difficult, so all states agreed to forever waive claims against each other, against any use related to that Republican River Compact prior to December of 2002. So it kind of cleaned the slate, if you will, and we were moving from 2003 onward as we dealt with this new allocation and the inclusion of wells under this FSS. There were some provisions in there that dealt with a moratorium on construction of new wells, which Colorado basically had in place already, but there were some exceptions to that we'll talk about that are important here, particularly as it relates to augmentation wells, and we'll talk about how that relates to our compact compliance pipeline. Obviously, if someone needs to replace a well, there's provisions to allow replacement, and just some other provisions like the allowance of domestic or small capacity wells to continue to exist. There's also a provision in the portion in Nebraska that's not subject to this moratorium as well, and it'll relate to one of the projects that Scott's going to touch on as well. One of the things that was key to settlement of the final settlement stipulation that was being developed as that was being negotiated was the development of a groundwater model. All of the three states recognized if we're going to make decisions on how to move forward in the future and to do accounting and to understand the impact of these wells on the stream system, we needed a groundwater model to do that because you can't measure underground like you can surface water in the streams. So the three states agreed to work together and formed a committee to develop this comprehensive groundwater model. And to develop, what the timing and location and amounts of these depletions of these wells would be. And they were charged with trying to get that done by July of 2003, and it's referred to the RRCA groundwater model. And there's Jim Slattery, who's here and works for the district, was involved in a lot of that work as well as some of our predecessors. The other provisions that came out of the final settlement stipulation for future compact administration were these revised accounting procedures that put in more detail how we're going to do this accounting for all three states, particularly as it relates to groundwater diversions and the consumptive use, how it's computed from that. Colorado has a 5-year running average that we use in terms of our compact compliance. The other states have similar things. There are some provisions under water short year administration. We won't get into a lot of detail about that, but some other provisions kick in terms of our accounting and requirements and steps the states have to do when we consider ourselves in a water short year administration like we are considered in this year and like we were last year. But there's a lot of information that's exchanged and gathered through this process now after the FSS that's very important. You can't manage what you don't measure, so there's a lot of this data that's gathered and shared between the three states. But unfortunately, there's still some conflicts and disagreements over what that data actually represents. We made some commitments between the states under the FSS for future joint efforts. We wanted to conduct some studies that were out there. Some of these have been done, conducted. Some of them are still underway. But there was basically an inventory done of these non-federal reservoirs. There's about 8 major federal reservoirs that are in the basin. Bonnie Reservoir is the only federal reservoir that's in Colorado, and we'll touch on that a little bit as well. But there was a study that was undertaken that looked at what the effects of land terracing is, and also there were some investigations into this feasibility of the improving the water delivery and storage infrastructure in the Bostwick irrigation districts. They aren't in Colorado, but down in Nebraska and Kansas. One of the other provisions that came out of the final settlement stipulation the three states agreed to was this mandatory dispute resolution process. It was an attempt, I think, that the Supreme Court didn't want every time the states had a disagreement, they'd be filing these actions before the court to have the court resolve them, to try to force the states to work together in a more cooperative way. And so they imposed, the states agreed on this dispute resolution process. Interestingly enough, the compact is silent on enforcement in regards to the implementation of the FSS, but we recognize and know that if there is a dispute between the states and we can't agree, that we can seek resolution of those matters, or at least consideration by the U.S. Supreme Court. So there's specific procedures that are in the FSS. It talks about this dispute resolution process. It's got a non-binding arbitration process. The states could also agree to a binding arbitration process, which we've not done. Scott will talk about all of the dispute resolution processes we've gone through, have all been non-binding resolutions by the arbitrator in those. Some of the process here I'll just outline quickly for you and then turn it over to Scott of how we go through a dispute resolution process. The states that are wanting consideration of a project that needs to be voted on by the RCA, the FSS requires a unanimous decision by all three states. So effectively, one state by voting no can hold up any project. So we have to at least seek a vote by the three states. If any one state votes no on that project, it can trigger this non-binding arbitration process. That state who's aggrieved by that decision can invoke this process, either a regular process that doesn't have any timelines associated with it, or this fast-track process that says it has to be completed in 180 days. And I believe all of the dispute resolution processes we've been under have been under the fast-track arbitration section. And then once we go through that process, Scott's going to talk about some of those specifics that we've been through. The states then have a decision, depending on the decision of the arbitrator, which is non-binding, whether they want to file a bill of complaint to the U.S. Supreme Court for consideration of a resolution of that issue if the states couldn't come to an agreement after the arbitration process. So I'm going to turn it over to Scott, and he's going to talk about some of the current disputes we're going through, and then we'll wrap it up.
Thanks, Dick. So I am going to talk about the current disputes that Colorado, Kansas, and Nebraska are involved in under the final settlement stipulation that Dick just discussed. At the end, I'll also talk about our current case between the three states that's in the U.S. Supreme Court. So that has progressed all the way through the mandatory dispute resolution requirements. It's been at several hearings in front of a special master of the Supreme Court, and now we're getting ready to appear in front of the 9 justices of the U.S. Supreme Court. So you'll see a list here of the current disputes going through arbitration. I think they represent a common understanding between both Nebraska and Colorado that in order to avoid future suits by Kansas for violating the compact, the states would have to either severely curtail groundwater use or come up with a plan of their own to help augment surface flows in the rivers. Colorado, the state of Colorado and the district have worked closely to develop the compact compliance pipeline, which I'm sure many of you are very familiar with. That's one of the cases that we've taken through arbitration. Colorado also developed a plan to change the accounting to reflect the fact that Bonnie Reservoir is no longer storing water, and that plan would have brought us into compliance on the South Fork. And I'll get into the details on Colorado's plans, but I want to just give you an overview of everything that's there. Nebraska has 2 augmentation plans of its own. One is the Rock Creek Pipeline Project. The other is their NCORP project on Medicine Creek. Both are similar to Colorado's pipeline, where they're using a series of wells to pump water into a pipeline and deliver that to the surface stream. Nebraska also had a plan for some alternative accounting during water short years. It's not something that really involves Colorado to any extent, but it's a plan that we were involved in arbitration. This map just shows the locations of some of these projects that I mentioned. The CCP project, Colorado's pipeline, you can see here. Rock Creek is here, just over the border. The NCORP pipeline on Medicine Creek is up here in the northern part of the basin. These are wells that are outside of the moratorium area that Dick described earlier, so not subject to some of the same restrictions that wells that supply Rock Creek and CCP are subject to. And for reference, there's Bonnie Reservoir down here in the south. So Colorado had 2 plans that it recently took through the arbitration process: the pipeline proposal for the CCP and Bonnie Reservoir. Some of you may remember that Colorado previously arbitrated the pipeline proposal in 2010. We arbitrated it again in 2013. And the way this works is Colorado and the district prepare the plans, submit those plans to the RRCA that consists of those 3 members from Colorado, Kansas, and Nebraska. Colorado and Nebraska voted in favor of Colorado's plans. Kansas voted against the plans. That triggers the dispute resolution requirements, and we end up in arbitration, which you can think of just like a trial, other than the fact that the decision at the end is non-binding, because that's what we agreed to in 2002 as part of this final settlement stipulation. So we went through the hearing in September. We received decisions on both of our plans from the arbitrator in November, and then in December, the states had to indicate whether they had accepted or rejected those decisions. Now, for a little more detail on the proposals themselves, the compact compliance pipeline proposal involves 8 wells that were changed from irrigation to augmentation. And those wells are connected to a pipeline that delivers water to the North Fork, just upstream of the state line, about a quarter mile upstream of the state line on the North Fork. As it says here in the slide, those wells that have been changed to irrigation, or from irrigation to augmentation, are still limited to their historical consumptive use. Under Colorado's law, that was a requirement of the changes. And So the proposal involved the infrastructure of the augmentation project, and then a method of calculating how much credit Colorado should receive for putting this additional water in the river. And the way we had proposed it is that Colorado receives credit for every drop of water that it puts into the river, and then that water is put into the RRCA groundwater model that Dick mentioned. And the groundwater model then considers how much of that water is depleted by groundwater pumping. And the same effect would happen no matter how you get more water into the river, whether it's through a pipeline or curtailing upstream use. If you have more water in the river, there's more there to deplete. So we use the model to determine those effects, and the two netted out, where you get your 100% credit for what's put in, and then the additional effects from wells. Not surprisingly, the issues that Kansas really disputed, the biggest one was how we had proposed to use the model to calculate that credit. Kansas did not want us to receive 100% credit for the water that was put in to the river. They would prefer, or their position in the arbitration was that they would prefer that we calculate how much of that water actually arrives downstream at Swanson Reservoir, which is how many miles downstream? It's quite a ways downstream, well past the state line. And they wanted to use the groundwater model to determine how much arrived there. Kansas also disagreed with the idea that Colorado could put water into the North Fork and use that additional flow to offset depletions from well pumping in the South Fork. And they wanted all of our augmentation credit to be limited to the North Fork and to have to do something separate on the South Fork. And then there were also some general complaints about operational limits and reporting, and some very detailed disagreements on the plan from Kansas. So after our arbitration hearing, our trial, in September, we got an interesting decision. I guess I'd say we sort of went in a stalemate, and we came out in a stalemate with Kansas. The arbitrator listened to all of the evidence and looked at the plan and considered everything together and said, well, Colorado, your plan in terms of how it uses the groundwater model to calculate the credit, that complies with the final settlement stipulation and the compact, but Kansas doesn't have to approve it, and their objections were reasonable. And she made pretty much the same analysis on the issue about offsetting South Fork depletions with deliveries from the North Fork, said that what we were proposing was consistent with the FSS and the compact, but Kansas didn't have to agree to it, and their objection was reasonable. Same thing on the operational limits. At the same time, we arbitrated our proposal on Bonnie Reservoir. And as I'm sure you all know, we drained, or an order was issued in 2012 to stop storing water in Bonnie Reservoir. That, by eliminating storage in the reservoir, that eliminated the evaporation charge that we faced every year under the compact accounting. But the model still calculated depletions, potential depletions to the stream, as if the reservoir were storing water. So our proposal went in to change that accounting, and I'll show you a slide to try to better explain this a little bit. So in addition to the reduced evaporation charge, we wanted an accounting change so that we weren't charged for this theoretical consumption. And you don't need to understand this full slide, and you can't, because it's a little compressed and you can't quite read the writing. But this top slide shows, let me do this so I can look at the slide myself. This top slide shows the current accounting and the way the model works. And essentially, the model calculates this baseline, this is a blue line, That shows stream flows with all states pumping their wells. And then the model goes through state by state and turns on and off wells. So the red line represents theoretical base flows if Colorado were not pumping its wells. This line right here represents Bonnie Reservoir on the South Fork. So when we go to calculate consumption today, the model charges us for this theoretical difference in base flow. So effectively, we get charged for this consumption. It also calculates consumption at the end of the basin. So this is the outflow of the South Fork into the main stem. And you can see here the red to blue line. We get charged for that consumption and that consumption. Our proposal said, we're not storing water in the reservoir anymore. That water isn't being depleted by well pumping because it's not sitting there in the reservoir to be depleted. Let's change the model so that it looks like any other tributary without a federal reservoir, where the only place we calculate the depletions is down here at the end. So it would track the water flowing all the way through the reservoir, and in the end, we would be charged with this much consumption. That was the basic accounting change. That is at the heart of the dispute with Kansas. Effectively, they're arguing that we're simply changing the accounting point and getting out of the potential consumption charge. So, as I said, the main disputed issue was that accounting change that we showed you. There was also a dispute with Kansas about our use of the unallocated supply on the South Fork. And as we calculate all of the allocations for all of the states on the various subbasins, in addition to a basin-specific allocation, there is what's called unallocated water. And the idea is that that unallocated water is left in the stream to contribute to the main stem flows, and then Kansas and Nebraska get use of the main stem flows. The final settlement stipulation says that you can use that unallocated on a first-come, first-served basis as long as you make up for it on the main stem. So we had argued that we can use all of that as long as all of that unallocated supply, as long as we make up for it with pipeline deliveries on the North Fork, which then go into the main stem and make up that main stem allocation where Kansas is entitled to use it. And Kansas, again, disagreed with that. They also raised an issue that Colorado should be charged for consumption of water by plants that were now growing in the bottom of the reservoir, which is contrary to the other terms of the compact, where no one is charged for consumption of water by plants that are not irrigated. So unfortunately, this slide isn't much different than the slide on the CCP dispute. We got a very similar decision. The arbitrator walked through our proposal, found that on each of these disputed issues, it was consistent with the final settlement stipulation in the compact, but said that Kansas shouldn't be forced to vote in favor of it. Now, and as Dick mentioned many times, these are non-binding decisions. So in the next slide, I'll walk you through sort of where we can go next. In the meantime, you may have read or you may have heard or you may have seen that we were able to negotiate at least a temporary approval to operate the compliance pipeline for 2014. I've got some of the highlights here. We began deliveries, I think, around January 17th, or I should say the district began deliveries. We think we should deliver about 4,000 acre feet by the end of this month. And again, this is all going to the North Fork. In April and then again September, we will look at our 5-year accounting average, annual precipitation, pumping records, use, all of that, and begin to calculate our total compliance for the 5 years and determine whether we need to deliver additional water toward the end of the year. If we do, those deliveries would occur in the winter months outside the irrigation season, and there's a schedule in the agreement that lays out when we would deliver that water if we need to deliver more. Total pumping for the year is limited to about 13,000 acre-feet from those 8 wells that feed the pipeline. I don't know that we'll get to the 13,000 acre-feet, but that's the absolute cap. That's really a function of the change of those wells from irrigation to augmentation. There's a small amount of water that's reserved for revegetation of the lands that have been temporarily dried up that were formerly irrigated by these wells as part of our agreement. And the agreement itself is limited just to the compact compliance pipeline on the North Fork. It does not resolve our South Fork accounting issues. So we have our temporary approval for the year. Our next steps that we may approach at the same time in parallel are to negotiate a permanent approval of the pipeline with Kansas. Nebraska has agreed to support us as we go forward negotiating, but it would be to negotiate a permanent approval with Kansas, negotiate a solution for the South Fork, or petition the Supreme Court to hear the case, and that would then fall under the court's original jurisdiction, and we would be in front of the court asking them to interpret the final settlement stipulation and the augmentation provisions to say whether or not we are entitled to the credit as we have calculated it in our proposal. So that's where we stand on Colorado's disputes. I have up here the 3 Nebraska disputes that I mentioned earlier, 2 of which I showed on the map. They're 2 augmentation projects. 2 of their projects are really at the same stage. They've gone through arbitration on the Rock Creek augmentation plan and on their alternative water short year accounting, which just changes the calculation for compact compliance during water short years. It changes from a 3-year average for them to a 2-year average, and they're allowed under the final settlement stipulation to come up with different ways to meet that average. So they wanted that approved. With a different arbitrator, Nebraska got a fairly favorable or a very favorable decision from the arbitrator, again, non-binding. And just last week or the week before, the first week of March, we were in Lincoln, Nebraska for the trial on their second augmentation plan, the N-Corp augmentation plan, that uses the wells that are outside the moratorium area to pump water into Medicine Creek. And this is a very big project. I think the annual limit is about 60,000 acre-feet of deliveries into Medicine Creek. So we had our trial. The states submit closing briefs on those, and then the arbitrator will issue a decision, I think, at the end of May, and the states have to choose by June whether to accept or reject the decision. So Nebraska is in much of the same position that we are, deciding whether it will try to negotiate permanent approval of its plans with Kansas, or whether it will go to the Supreme Court and try to get the Supreme Court to tell Kansas that it has to approve the plans. So those are all of the cases that we have arbitrated. And now I'll talk a little bit about the U.S. Supreme Court case that already went through the arbitration process. This was a case where Kansas sued Nebraska again, saying that Nebraska was violating the terms of the final settlement stipulation we entered in 2002 and the compact. Nebraska, after it got sued, joined us, Colorado, as a defendant. And in addition, they counterclaimed or sort of countersued Kansas, saying that they were being improperly charged for consuming Platte River water that seeped into the Republican River Basin as return flows from irrigation. Kansas, again, much like the case that Justice Hobbs talked about, Kansas sought pretty big damages, about $70 million in damages. The court to impose punitive damages and to punish Nebraska essentially for violating the compact. They asked the court to force Nebraska to shut down 300,000 acres of irrigated land. They asked the court to come up with preset damages for any future violations so that if Kansas believed Nebraska was in violation, they could simply walk into court and say they overpumped by 70,000 acre feet, multiply that by some dollar amount per acre foot, and Nebraska write us a check. They also asked for the court to appoint a river master who would oversee all of our compact compliance efforts and to tell the 3 states what to do and how to reach compliance and whether those proposed efforts were satisfactory or not. So Colorado participated in these hearings largely to protect its interests in the compact and other compacts, and the biggest issue for us were these damages claims, as you can imagine, looking at the potential threat of future litigation against Colorado for a compact violation. So we spent about 2 years in front of a special master of the Supreme Court. He acts sort of as a trial judge, hears all the evidence at trial, and then makes a recommendation to the court as to what they should do with our case. So, like I said, about 2 years in trial in front of him. This past winter, we received his final report, which is what he recommends the Supreme Court do with the case. And as you can see here, the special master agreed with Nebraska that Nebraska was being improperly charged for this water that was seeping in from the Platte to the Republican River Basin from irrigation in the Mound area, and said that the parties should reform the accounting procedures. That's something that we supported Nebraska on and participated pretty heavily at trial. The special master found that Nebraska's violation of the compact was not intentional, something that we think is very important in determining the level of damages that are awarded. The master also found that Nebraska's total overuse was quite a bit less than what Kansas had claimed, 22% less. He refused to approve any punitive damages, refused to calculate preset damages for future violations, and refused to appoint a river master in his report. So we were pleased with that. And I think this may be a similar case to what Justice Hobbs said earlier, where Colorado came out of its suit with Kansas claiming victory. Nebraska here, I think, is in a pretty similar situation. The special master found that damages to Kansas only amounted to $3.7 million. If you remember from a few slides ago, Kansas was seeking $70 million in damages claims. The troublesome part from Colorado and Nebraska's perspective is that the special master found that he could also force Nebraska to give up money that it might have gained by violating the compact, calculated that roughly at $1.8 million. The states, the procedure in front of the court is that the master files his report. The states are given an opportunity to file exceptions, which is basically an appeal. We say to the Supreme Court, you shouldn't follow these recommendations that the special master has made. So the one that Colorado has taken exception to is this award of Nebraska's gains. And we filed an exception in February saying that all of the damages should be limited to Kansas's losses and shouldn't include Nebraska's gains, largely because we need to protect our interests in future compact litigation. So there's another round of exceptions where we are now replying to Kansas's exceptions. They disagreed with the special master's recommendation to stop charging Nebraska for consuming Platte River water, and then, of course, argued that damages should be increased, and we're asking for $11 million in disgorgement of Nebraska's gains. So we'll be responding to those shortly, and then maybe in front of the Supreme Court next fall to argue the case and get a final resolution within probably a calendar year from today on that case. So I think we have a slide here for questions, but Dennis, am I correct that we're waiting and we will be available, Dick and I will be available this afternoon at the panel discussion to answer any questions that you have on this presentation or anything else about the Republican River Basin?